In the last section, we explored the major types of easements in Arizona: appurtenant, in gross, prescriptive, and by necessity, and how each one affects property ownership and use. Now, we turn our attention to encumbrances more broadly. While easements are one form of encumbrance, Arizona law recognizes many others, each influencing how real estate is transferred, used, or financed. Understanding the characteristics and methods of creating these encumbrances allows real estate professionals to identify potential title issues, explain them to clients, and ensure that property transactions comply with state statutes and commissioners' rules. An encumbrance is any legal interest, right, or claim that affects or limits a property owner's ability to transfer clear title or to use the land freely. Encumbrances may be financial or non-financial, and they can either burden the title, such as a lien, or restrict its use, such as a deed restriction or easement. According to ARS, paragraph 33-412, all encumbrances that are recorded in the county recorder's office serve as constructive notice to the public, meaning that any buyer or lender is legally presumed to know they exist. Types of encumbrances in Arizona. Encumbrances fall into two general categories: voluntary and involuntary. A voluntary encumbrance is created with the owner's consent, typically to secure a debt or financial obligation. Examples include mortgage liens, deeds of trust, and home equity lines of credit. When a borrower uses their property as collateral for a loan, they grant the lender an encumbrance, known as a security interest, that remains until the debt is paid in full. This type of encumbrance benefits both parties. The borrower gains financing, and the lender gains protection through a recorded lien. An involuntary encumbrance, on the other hand, is placed on the property without the owner's consent. This can occur through legal action, taxation, or statutory authority. Common examples include property tax liens, mechanics liens, judgment liens, and IRS liens. These encumbrances typically arise when a property owner fails to meet financial obligations, and they often take priority over other claims, depending on when they were recorded. For instance, under ARS, paragraph 42, 17153, property tax liens in Arizona automatically attach to real property on January 1st of each year and take precedence over all other liens. Methods of creating encumbrances. Encumbrances may be created through several methods, depending on their nature. By agreement, voluntary encumbrances, such as mortgages or deeds of trust, are created through written contracts between the property owner and another party. Once executed and recorded, these agreements become enforceable encumbrances that appear in the public record. By law, statutory encumbrances. Certain encumbrances arise automatically under Arizona statutes. Property tax liens and homeowners association liens are examples of statutory encumbrances that attach to property by operation of law, even without a recorded document. By court action, judicial encumbrances. Courts may impose encumbrances such as judgment liens to satisfy legal debts. Once a judgment is entered, the creditor can record a judgment lien against the debtor's property, creating a legal claim that must be satisfied before title can transfer. By operation of use, prescriptive or adverse encumbrances. Similar to a prescriptive easement, some encumbrances may arise from continued use or possession, such as through adverse possession or an unrecorded right-of-way that becomes legally recognized after long-term, open, and notorious use. Examples in practice. To understand how encumbrances function in real transactions, consider a few real-world examples. Example 1. A homeowner in Gilbert obtains a home improvement loan secured by a deed of trust. The lender records this document, creating a voluntary encumbrance. If the homeowner sells the property, the lender's lien must be paid off through escrow to deliver clear title to the buyer. Example 2. A contractor performs remodeling work on a property in Scottsdale, but is not paid for services. The contractor files a mechanics lien under ARS, paragraph 33981, which encumbers the property until the debt is settled or the lien is released. Example 3. A homeowner fails to pay property taxes. The county treasurer records a property tax lien that takes automatic priority over all other liens. If unpaid, the lien may lead to a tax sale or foreclosure under ARS. Paragraph 42, 18101. Example 4. A property in Tucson is subject to a restrictive covenant, stating that only single-family homes may be built on the lot. This restriction, recorded in the CC&Rs, is a non-financial encumbrance that limits how the property can be used but does not affect ownership. Encumbrances and title. Encumbrances are routinely identified in title reports and are critical to determining whether a seller can convey marketable title. Marketable title means ownership that is free from significant defects or claims that could affect value or use. While some encumbrances, such as utility easements or HOA restrictions, are common and acceptable, others may require resolution before closing. Escrow officers often work with lenders, title companies, and attorneys to ensure all liens are paid off or released before transferring ownership. Failure to disclose or clear an encumbrance can result in legal consequences. Under ARS, paragraph 33-420, any person who knowingly records a false or groundless document that purports to encumber real property may be liable for damages and attorney's fees. This statute protects property owners from fraudulent filings and ensures the integrity of Arizona's recording system. Case example: Wyatt v. Waymueller, 1987. In this Arizona Supreme Court case, a party recorded a false lien against another's property without valid legal grounds. The court ruled in favor of the property owner, awarding damages under ARS, paragraph 33-420. The case illustrates the seriousness of recording encumbrances and reinforces the importance of verifying their legitimacy before recording. Discussion. What is the primary distinction between a voluntary and an involuntary encumbrance? Answer. A voluntary encumbrance is created with the owner's consent, such as a mortgage lien, while an involuntary encumbrance arises without consent, such as a tax lien or judgment lien. How can an encumbrance affect a property's title? Answer. It can limit the owner's ability to transfer clear title or reduce the property's market value until the encumbrance is resolved or released. What statute protects property owners from fraudulent or false encumbrances? Answer. Arizona law under ARS. Paragraph 33-420 prohibits the recording of false or groundless encumbrances and allows for damages to affected property owners. Review. Summary encumbrances are legal interests or claims that affect ownership, transfer, or use of real property. In Arizona, encumbrances can be voluntary, created through agreement, or involuntary, arising by statute or court action. Common examples include mortgages, tax liens, judgment liens, mechanics liens, easements, and deed restrictions. Each encumbrance must be properly recorded to provide notice to the public, and sellers must clear or disclose them before conveying title. Understanding the nature and creation of encumbrances helps licensees protect their clients and ensure compliance with Arizona law, particularly regarding title verification and disclosure.